Good afternoon everyone, and welcome to the final of the Kirby Cup High School Mooting Competition for 2019. First, I'd like to say congratulations to our two teams, Our Lady of Mercy College Parramatta and Pinball Ladies College. In this final, Our Lady of Mercy College will represent the plaintiff and Pinball Ladies College the defendant. Our bench today consists of three very illustrious judges. John Landerer, CBEAM, is the Managing Director of Landerer and Company. Professor Anna Cody is the Dean of the School of Law, Western Sydney University. The Kirby Cup High School Mooting Competition is named after our Chief Judge, the Honourable Michael Kirby, AC CMG. Michael Kirby has been a regular visitor to the School of Law since its inception, and we are very grateful to him for the permission to use his name in this competition. And I'd ask that everyone please warmly welcome our panel of judges. I will now hand the court over to our bench to begin the moot.
The court will now take the appearances of the parties.
May it please the court, we the appellant appear on behalf of Mr. Nu Singh in the case of Singh and Barbara. My name is Crystal Wynn and I'm here with my learned junior, Miss Thomas, and we are instructed by Miss Chakti.
Yes, thank you, Miss Wynn.
May it please the court, my name is Tang and I appear with my learned junior Cook for the first respondent in this matter. We are instructed by Tang.
Yes, thank you, Miss Tang. We will hear first from the plaintiff, and Ms. Wynn, you are to lead off. I should indicate that the Chief Justice has certified that, having regard to the seriousness of this matter and its complexity, the court should on this occasion be constituted by 3 judges, and that is why we are here as we presently are. Yes, Ms. Wynn.
May it please the court, the 3 grounds of appeal we will be addressing today are: firstly, the cultural object was not a knife under Sections 3.1 and 11C1 of the Summary Offences Act 1988. Secondly, Mr. Singh has reasonable excuse under Sections 11C 1 and 2 of the Summary Offences Act 1988. Thirdly, Mr. Singh did not have a permit to carry the weapon under the Weapons Prohibition Act 1998.
Can I ask, is there a Kirpan or Sikh knife in court that the court can look at?
No, Your Honour.
There is not. Okay. Well, we do have some photos in the record and we have looked at those.
Could I ask that the third ground be repeated?
The third ground, Your Honour, it's that Mr. Singh did not have a permit to carry the Kirpan under the Weapons Prohibition Act 1998.
Yes.
May it please the court, it is our argument that the Kirpan is not a knife, which is what my learned colleague will be addressing. However, regardless of what the cultural object is defined as, Mr. Singh still had reasonable excuse in all aspects. As such, Your Honour, I will be addressing submissions 2, whilst my learned junior will be addressing submissions 1 and 3. If it pleases the court, I will now begin with submission 2. Your Honour, may it please the court, Mr. Singh has reasonable excuse under Sections 11C 1 and 2 of the Summary Offences Act 1988. Before I begin demonstrating why Mr. Singh had reasonable excuse to carry the Kirpan in a public place, we must first consider the meaning of reasonable excuse itself. It is an excuse that an ordinary member of the community would accept as reasonable in the circumstances provided. The concept of having a reasonable excuse must be applicable for the everyday man. When there is a reasonable excuse, there is an avenue for carrying the object. Therefore, the learned magistrate Barbara erred in not considering the possibility of reasonable excuse.
The first question is whether or not the Kirpan is a knife within the meaning and extended meaning of the statute. Is that correct?
Yes, Your Honour.
Very well. Well, you proceed.
Reasonable excuse for Mr. Singh falls under 5 points. the pursuit of education, participation in lawful recreation, the wearing of an official uniform, genuine religious purpose, and lawful purpose. May it please the court, I would like to start my submissions at point 3, which speaks to genuine religious purpose.
Yes.
In sections 11C, 1 and 2 of the Summary Offences Act 1988, it is said that having genuine religious purpose would enable an individual to carry a knife. The kirpan is part of a religious doctrine issued by Guru Gobind Singh, a significant figure in Sikh religion, in 1699. The commandment requires all Sikhs to wear the 5 Ks, including the kirpan. Therefore, Mr. Singh was only following these religious commandments, giving him genuine religious purpose.
Can I ask you, please, if he were carrying a gun because that was prescribed by his religion, would that be reasonable?
No, Your Honour. While these commandments may seem outdated, it reflects a view that has stood the test of time. As wearing the kirpan was part of a religious doctrine of the faith, Mr. Singh was required to wear it in the present. The Sikh faith has clear guidelines on when the cultural object can actually be used.
No, but what I'm asking you is, say, forget the Sikh religion, any religion prescribed that you have to carry a gun in a holster as part of your religion. Is that a reasonable excuse?
No, Your Honour, but it depends on the context of the matter. So,
Maybe if it was a toy gun and it was only carried for the purpose of your religion, there would be no offence to a prohibition on the use of a gun which implies a bullet. But in this case, we're concentrating on the kirpan, and I noticed that in the statute the definition of knife is a knife blade, a razor blade, or any other blade. So is there anything turning on the use of the word blade, which in my mind conjures up the idea of something thin and sharp, and maybe not the kirpan which is shown in the photograph, which appears to be rather blunt and ceremonial. Do you agree that the kirpan that Mr. Singh was carrying was a blade?
yes, Your Honour.
Well, if so, we don't have to worry about whether it doesn't meet the requirement of a blade. Is your position that you accept that it's a knife, but you say that he was reasonable in carrying it? Is that how you're putting your case? Or do you deny that it is a knife for the purpose of the act?
Or are those submissions that your co-counsel is going to address us on?
Yes, Your Honour. My co-counsel, Ms. Thomas, will be addressing this issue.
Well, we'll postpone our fascination with that question until the submissions are heard from Ms. Thomas. You proceed with your submissions, Ms. Wynne.
Yes, Your Honour. As Mr. Singh was only following these religious commandments, it gave him genuine religious purpose. So, genuine religious purpose is the religion's requirements, which are not to harm another person, but are required to be followed in order for the person to fulfill their faith. Mr. Singh also, I will now be looking at point 1. It is stated in sections 11C, 1 and 2 of the Summary Offences Act 1988, a person having custody of the kirpan is classified as a reasonable excuse if it is the lawful pursuit of the person's occupation or education. In Mr. Singh's case, he is in the pursuit of education in the Sikh faith. One of the ways that can help in the pursuit of an individual's education is by attending a religious festival. The attendance of a religious festival enhances the individual's understanding of their faith and provides them deeper knowledge regarding their religion. By having a strong understanding of their religion, this is a common goal in several religions. As such, Mr. Singh, being in attendance of the religious festival, called to him to carry the kirpan to represent his standing in the Sikh faith, as this was to abide by the religious commandments. Mr. Singh was provided with reasonable excuse to carry the cultural object, as it was in the pursuit of his education. My second point is that in sections 11C, 1 and 2 of the Summary Offences Act, 1988, it states that participation in lawful entertainment, recreation, or sport. In the Oxford Dictionary, the word recreation is defined as an activity done for enjoyment. This is in reference to the second point of why Mr. Singh had reasonable excuse. The religious festival Mr. Singh attended at Fairfield Showgrounds was a recreational event for the people of the Sikh faith. The attendees were there to take pleasure in practicing their religion with other members of their faith. Hence, the participation in the communal event as a Sikh required Mr. Singh to carry the kirpan in pursuit of the recreational festival, defending his reasonable excuse. Furthermore, the practice of carrying the kirpan each day is for Mr. Singh's religious obligation and enjoyment because he wanted to fulfill his faith.
So is it your submission that he was carrying it for both genuine religious purposes and for participation in a lawful recreation activity? So both grounds,
Yes.
Both exceptions. Thank you.
Is that, if that is accepted by the court, is that a complete answer to the prosecution in your submission? Or is there still a requirement of securing the concurrence or permission of the Commissioner?
Your Honour, could you please rephrase the question?
Under the Act, you have a defence if you're carrying the knife is for genuine religious purposes and recreational. Is that a complete defence, or is it still necessary to have the Commissioner's permission or permit?
It is a complete defence, Your Honour.
You say that's enough if you prove that it's being carried for reasonable excuse and on any of those grounds that are stated?
Yes, Your Honour, as in section 11C, 2, it states that the custody is reasonably necessary in all the circumstances for any of the following. Therefore, when one of these is acceptable, only one of these needs to be accepted to be proven.
That's under the Summary Offences Act, but there is another act, and that is the Weapons Prohibition Act. The Summary Offences Act is 1988 and the Weapon Prohibition Act is 1988, and that appears to add a specific requirement in the case of prohibited weapons that you still have to be authorised to carry them by a permit issued by the Police Commissioner. Are you dealing with that issue, or is that going to be
Your
dealt
Honour,
with
my
by Ms.
learned junior
Thomas?
will be addressing that issue.
All right. Well, I think your time has expired. Is there anything you want to say that you haven't been able to say because you had so many questions from the court?
Just to clarify that if one of these criteria are proven, then it would be acceptable as a reasonable excuse. That is all. I will now be passing to my learned junior, Ms. Thomas.
Thank you very much. So would you tell us what issues you're going to deal with, Ms. Thomas?
Your Honour, as the junior counsel for the appellant, I will be addressing our first and third grounds of appeal on the cultural object that was not a knife under sections 3.1 and 11C(1) of the Summary Offences Act, and Magistrate Barbara's misdirection as to the law in finding that Mr. Singh did not have a permit to carry the Kirpan under the Weapons Prohibition Act.
Yes.
If it pleases the court, I will now be speaking on our first ground of appeal. Your Honours, the Summary Offences Act 1988 defines a knife as a knife blade, a razor blade, or any other blade. Now consider the appearance of the cultural object. The Kirpan is curved and has a single cutting edge that can be blunt. Although the Kirpan's appearance may suit to that of a knife under the Summary Offences Act, its appearance speaks differently than its intent. And as such, Magistrate Barbara erred in concluding that the Kirpan is a knife, but only speaking to a knife's definition under legislation, but not intent.
I see that you pick up the point about the blade. A knife under the Act is not just a knife as you would normally think, a butter knife or something like that. It's defined, and it's defined to include a blade.
Yes, Your Honour.
And when one looks at the photograph of the Kirpan, it appears to be a rather blunt object. Do you submit that in relation to the item at paragraph 3 of the Statement of Facts that we should draw the inference that the Kirpan does not have a blade?
Your Honour, the Kirpan does have a blade, and although that might suit to the definition of a knife under legislation, we must also need to take in the intent of what a knife is commonly used for, and then what the intent of the Kirpan is used for.
Yes, very well.
This is seen in the case of Coleman and DPP 2000 NWSC 275, where Justice O'Keefe found that a definition of an item is not limited to its definition under legislation, but also extends to its intent. As such, in the case, a criteria of dress, body language, and verbal language is created to appropriately define an object. In our case today, Mr. Singh fits all three of the criteria set above, demonstrating that the Kirpan was not a knife. In dress, Mr. Singh was attending a Sikh festival, insinuating that he was wearing his full cultural uniform, which consists of the 5 articles of faith, one being the Kirpan. In body language, Mr. Singh wore the Kirpan affixed to the side of his belt in a non-aggressive manner, indicating that he never intended to use the cultural object.
Can I ask you this? What does in a non-aggressive manner mean when you're wearing something on your belt?
Well, Your Honour, Mr. Singh, an aggressive manner would mean that Mr. Singh was holding the knife, or it would look like that he was about to use the knife.
But it was capable of being used, wasn't it?
Was
it capable of being used if he so wanted to?
If he so wanted to, he could use the knife, but that was not his intention. The Kirpan is purely symbolic.
I understand that, but I didn't understand when you said he didn't wear it in an aggressive manner. I think it becomes an aggressive manner if he does something aggressive, doesn't it?
Your Honour, the Kirpan was also covered with protection in the sheath. So that would also speak to it being not an aggressive manner.
Well, I guess a gun's held in a holster as well.
Your Honour, we concede to that. And in verbal language, when being questioned by the constable and detective, Mr. Singh responded calmly and with a non-threatening stance, explaining that the object was in his possession for religious purposes. These religious purposes date back to 1699, where Guru Gobind Singh instructed all specially baptized Sikhs to uniformly wear the 5 articles of faith. Your Honours, the purpose of wearing the Kirpan is purely symbolic, as it reminds the individual that it is their duty to help others, but not by the means of the Kirpan, more like alerting authorities or summoning help. In fact, the term Kirpan in English translates to mercy, kindness, and compassion.
Can I interrupt you there? If it has a blade on it though, and it can be used to hurt someone and as a cutting instrument, then doesn't it fall within the definition of knife?
Your Honour, although it does fall under the definition of the knife, the definition should also include the intent. By considering this criteria, it is evident that Mr. Singh's uniform actions speak to his intentions, defining the cultural object as a religious ornament and not as a knife. May it please the Court, I will now be addressing Submission 3. The Summary Offences Act 1988 sets the guidelines for what a knife is and when it is acceptable to hold. As such, if an individual does not have a permit or is not liable for one under the Weapons Prohibition Act, they may be charged under the Summary Offences Act. Your Honour, the question of materiality stems from whether Magistrate Barbara erred in finding that Mr. Singh did not have a permit to carry the Kirpan and was not liable for one. Magistrate Barbara's misdirection of the Weapons Prohibition Act is material to Mr. Singh's case, as appropriate direction of the Act would result in a different decision and would null the Summary Offences Act. In the case Minister for Immigration and Border Protection and SZMTA, it is stated that identifying a wrong issue, asking a wrong question, ignoring relevant material, or relying on material in a way that affects the exercise of power is to make an error of law. It is conceded that Mr. Singh did not have a permit. However, Magistrate Barbara misdirected herself as to the law in ignoring relevant material by finding that Mr. Singh was not liable for a permit under the Weapons Prohibition Act, as it does not envision a genuine religious purpose. Your Honour, let's take a look at the Weapons Prohibition Act.
Where is the definition of a prohibited weapon?
Your Honour, I do not think there is a definition under legislation of a prohibited weapon.
Can we assume that it includes a knife with a blade?
Yes, Your Honour, I think that is correct. We can assume that prohibited weapon is set by the guidelines of the Summary Offences Act, and although the Kirpan may look like a knife, Mr. Singh had every right to get a permit for it, especially on this particular religious festival.
So why didn't he get a permit?
Your Honour, Mr. Singh was not aware that he had to get a permit.
Not being aware of a law, is that a defence?
Yes, Your Honour, but because this is an offence of him not being aware of the law, that is a breach of the Weapons Prohibition Act and not the Summary Offences Act, which is what Mr. Singh was convicted under. So we concede that Mr. Singh did not have a permit and was not aware to obtain one.
Yes, press on.
Okay. Your Honour, Section 11.2 of the Weapons Prohibition Act states that the Commissioner may determine that an applicant has a genuine reason for possessing or using a prohibited weapon if the applicant states that he or she intends to possess or use the weapon for any one or more of the reasons set out in the table to the subsection. The table provides the genuine reason of a recreational or sporting purpose, which is analogous to Mr. Singh, as the religious festival he was attending is considered a recreational purpose, and so is the act of carrying the cultural object. The definition of recreation under the Oxford Dictionary is a particular activity that someone does for enjoyment. Your Honour, this reflects the religious festival Mr. Singh partook in, as he was involved in the festival for his own enjoyment, and carrying the cultural object is an obligation for recreational religious reasons and represents his standing in the Sikh faith. This key element was ignored by Magistrate Barbara, and as such, she erred in stating that Mr. Singh would have never had justification to have a permit. Your Honour, when bearing in mind all the arguments my learned colleague and I have outlined today on Appeals Ground 1, 2 and 3, it is without a doubt that Magistrate Barbara did err in finding the Kirpan as a knife and in finding that Mr. Singh had no reasonable excuse for carrying the Kirpan in a public place, and misdirected herself as to the law in finding Mr. Singh without a permit under the Weapons Prohibition Act. On Appeals Ground 1, I demonstrated that whether or not the cultural object looked like a knife, labelling it as a knife also speaks to its intent, which was not for it to be used as a knife. proving that the cultural object cannot be defined as a knife under the sections 3(1) 11C of the Summary Offences Act. I also spoke on Appeal Ground 3, which demonstrated that Magistrate Barbara misdirected herself as to the law. And my learned colleague proved that Magistrate Barbara had also erred in not finding Mr. Singh to have a reasonable excuse, despite him pursuing his religious education, participating in a recreational event, wearing an official uniform, having genuine religious purpose, and having lawful purpose. Evidently, Mr. Singh should have not been found guilty of contravening Section 11C of the Summary Offences Act. And I've been looking forward to answer those questions if you wanted me to.
Yes, I think you've dealt with the matter very clearly. Thank you very much, Ms. Tollis.
Thank you.
Now, Ms. Tang, you're going to present the first arguments for the respondent. Are you going to deal with them in the three issues that they are raised in the notice to the court?
Yes, Your Honour.
Namely, is it a knife, and did the appellant have reasonable excuse, and then the issue of the permission to carry it under the Weapons Act?
Yes, Your Honour.
They the three, and what is the division between you and Ms. Cook?
Your Honours, I will be addressing the first and second submissions, while my learned junior will address the third.
Very well. Press on, please.
Your Honours, this case involves the lawful conviction of the plaintiff, whose motivations for carrying the contested weapon have been rightfully characterised as being dangerous and posing considerable harm to the wider community. The facts of the case are as follows. On May 26th of this year, the appellant, Mr. Singh, attended a religious festival at Fairfield Showground, during which he carried on his belt a kirpan, a curved sword or dagger with a single cutting edge, carried by practising Sikhs. During this festival, Mr. Singh was questioned by police as to the reason for his possession of a prohibited weapon in a public place. Mr. Singh explained that he did not possess a permit and was later found guilty in the local court of New South Wales of having contravened Section...
Yes, we have read the facts. We know the facts.
Yes, Your Honour.
What is your submission in relation to whether a kirpan is or may be a knife under the Act, Summary Offences Act?
Yes, Your Honour. In the present case, counsel for the respondent will make three submissions, with those being, first, that the learned magistrate did not err in so finding a kirpan to be a knife. Second, that the learned magistrate's finding that the defendant did not have a reasonable excuse was legally reasonable. And third, that the learned magistrate did not misdirect herself as to the law in so finding that the defendant did not have a permit to carry the kirpan. As I mentioned earlier, the division between myself and my junior counsel is comprised of myself addressing the first two and my junior counsel addressing the last. If it pleases the court, I will now make our first submission. Your Honours, in this submission, the issue for determination is whether or not a kirpan is a knife. We submit, on the basis of its essential class, nature and purpose, that the contended kirpan is indeed a knife and must be considered as such for the maintenance of public safety. In so doing, we would examine closely the relevant Section 3, subsection 1 of the Summary Offences Act, which provides that a knife may be A, a knife blade, B, a razor blade, or C, any other blade. To this statute, we would accept and apply the method of statutory interpretation used in the case of Coleman against the Director of Public Prosecutions, heard in the year 2000 in the Supreme Court of New South Wales, volume 275. In Coleman, Justice O'Keefe adopted a three-pronged approach to interpreting the statute, consisted of, first, considering the ordinary plain meaning of the word, second, identifying the purpose of the statute, and third, examining relevant decided cases. We submit that the facts of the present case, although distinguishable from that of Coleman, are sufficiently similar such that they continue to make relevant the approach taken by Justice O'Keefe. As such, we would submit that the third element of this method has been satisfactorily fulfilled. Your Honours, in relation to the first element of statutory interpretation, we would consider the ordinary plain meaning of the word knife to be as provided in three commonly used dictionaries, which are as follows. The Oxford Dictionary provides that a knife is an instrument composed of a blade fixed into a handle used for cutting or as a weapon. The Cambridge Dictionary provides that a knife is a tool, usually with a metal blade and handle, used for cutting and spreading food or other substances, or as a weapon. Finally, the Collins Dictionary defines a knife as a tool for cutting or as a weapon, consisting of a flat piece of metal with a sharp edge on the end of a handle.
The purpose of the Summary Offences Act is to have a provision that will permit the ready prosecution of somebody who is relevantly carrying a dangerous weapon, a knife with a blade that can do harm to other human beings, because of the experience of society that young people, usually young males who carry these weapons, can use them and do a lot of damage, even kill people. So the question is a kirpan that kind of knife, or is it really just a ceremonial toy? That's the question.
Yes, Your Honour.
What do you say?
Yes, Your Honour. In consideration of the fact that the term blade appears in all three provisions of this particular section, we would submit that the contested kirpan indeed fits the definition of a blade, as according to the Cambridge Dictionary, which provides that a blade is the flat cutting edge of a knife. And therefore, given the appellant's circumstances, we would submit that indeed the kirpan that he possessed fits the definition of a knife, Your Honour.
Can I ask you, is there any evidence whether anyone else was wearing a kirpan in this festival?
No, Your Honour. There was no other evidence as to that fact.
It seems strange that only he was arrested.
In the Kirby Cup brief, it was provided that this practice of carrying the kirpan was usual practice for the appellant, and as such, it was something that he engaged in every time he left his place of residence.
This was a specific Sikh festival, was it not?
Yes, Your Honour.
With a lot of people from the Sikh community, and everyone knows that the Sikhs have to have certain dress items, including the ceremonial knife. I mean, you don't have to know a lot about Sikhism to know that. So why were the two policemen there? Were they just waiting to catch somebody with a knife?
Your Honours, I would submit that given the fact that Fairfield Showground is a public place, in which, as Your Honour mentioned, there are a number of members of public, including families with young children, the police acted in a way so as to ensure that the purpose of the statute was upheld, that is, the maintenance of public safety in this particular circumstance.
Yes. Well, you say that, like it or not, this is a knife because it has a blade, it can do harm to people, it may have only been worn for ceremony, but unfortunately ceremonies can sometimes end up in tears, and therefore this is within the purpose and words of the statute.
Yes, Your Honour.
Yes, very well. Press on to point 2, assuming the court is against you on that, or assuming it accepts that.
Yes, Your Honour.
Why is it not reasonable for Mr. Singh to carry it, given that this was a Sikh cultural occasion, that Sikhs carry the ceremonial knife? Why would that not, in contemporary Australia, be reasonable that he should carry it?
Yes, Your Honour. I will now proceed to make my second submission. In this second submission, the two issues for determination are as follows. First, whether or not the learned magistrate's finding was legally unreasonable, and second, whether or not the appellant had reasonable excuse for carrying the kirpan. In light of our present conversation, I might move on to proceed to address the second point of this, that is, whether or not Mr. Singh had reasonable excuse for possessing the kirpan. So, Your Honours, we would submit that the appellant did not have reasonable excuse for possessing this kirpan, as we would submit that a purposive approach be adopted by Your Honours in consideration of the purpose of the relevant Section 11, capital C, subsection 1 of the Summary Offences Act. And as we would submit that this purpose pertains to the maintenance of public safety, we would uphold the judgment of the learned magistrate that Fairfield Showground is a public place, and that Mr. Singh's possession of the kirpin presented an act contrary to the maintenance of public safety. And as such, we would examine the relevant section 11C, subsections 2 and 3, which states that it is a reasonable excuse for a person to have custody of a knife if they have genuine religious purposes. However, it is not a reasonable excuse for a person to have custody of the knife solely for the purpose of self-defence or the defence of another person.
Yes, well, that's not relevant in this case. What is relevant is whether or not it was reasonable on the other grounds mentioned in the Act, which relate to religious purposes. Why was he not carrying it for religious purposes?
Your Honour, we would submit that on the appellant's evidence, this practice was something that he engaged in daily, and the supposed religious purposes for which the article of faith is mandatory for baptised Sikhs is for the defence of the needy or the suppressed ones. And as such, we would submit that this is not a genuine religious purpose, as this, in fact, would be considered an act of threat or of endangerment to the well-being of another individual.
But sorry, if the religion or the 5 commandments say you have to wear a kirpan, why is that not a reasonable ground on his part to abide by his faith?
Your Honour, we would submit that in light of the current context, that is the contemporary Australian context, there is ample opportunity for practising Sikhs to exercise their religious freedoms through other methods or other avenues. Some Sikhs have been known to carry a symbolic medallion or a photograph of the kirpan in observance of Guru Gobind Singh's 16.
Well, why would that be relevant? Some people may want to do that and other people may want to abide by the strict requirements of their religion.
Yes, Your Honour, we do concede that religion is a very personal and subjective thing, and that practising Sikhs do have the right to exercise the right to religion in whatever way that they see fit.
So why is it not reasonable for him to have had the kirpan?
It is not reasonable for the appellant to possess the kirpan because it poses as a threat to the surrounding members of society, and we would submit that in this case the overall well-being and public safety be considered first.
But does the Act say that it's reasonable only if it doesn't create a threat? Does the Act say that? Or are you implying that?
Sorry, Your Honour, might I ask you to rephrase the question?
Are you saying that the Act provides that it's only reasonable to carry a kirpan if it's not a threat to others?
No, Your Honour. There are a number of provisions outlined in that Act, in which case possession of the kirpan might qualify as reasonable excuse.
Well, now I think your time. I'm sorry.
I'm just going to ask one other question
Yes, Your Honour.
in relation to the submissions that we've previously heard. So one is religious purposes, but the other submission has been around participation in recreation, which we've heard is the other reason that may be a reasonable excuse. What's your response to that?
Yes, Your Honour. So in response to recreation as being the reasonable excuse, we would submit that this is not true in the present case, as first of all, on the appellant's evidence, there was no evidence to show that there were multiple acts of recreation at this particular Sikh festival. Further, we would submit that this act of carrying the kirpan is not a one-off for this particular festival, and therefore it does not qualify as an act of recreation for the purposes of engaging in activity at this festival, as this is something that the appellant carries. The kirpan is something that the appellant carries every single day, and we would submit that unless the appellant engaged in recreation each time he left his place of residence, that this act would not qualify as an act of recreation, Your Honours.
What would you say if he had gotten a permission from the Commissioner?
If Mr. Singh had received a
Is
permit.
that something that is going to be dealt with by your co-counsel?
Yes, Your Honour. My Leonard Junior will address that submission.
Well, I think you're out of time, so I think we might ask her to answer that
now hand
question
over.
asked by Justice Landerer. Thank you for your assistance, Ms Tang. Now, Ms Cook, I think you tell us what you're going to deal with, and then when it's convenient, if you would answer Justice Landerer's question, last ask of your co-counsel.
Yes, Your Honours. My appeal ground is Appeal Ground 3, and it is that the learned magistrate was correct as to the law in so finding that Mr Singh did not have a permit to carry the prohibited weapon, and if it pleases the court, I will be answering that question within my submissions. May I continue?
Yes.
Thank you. May it please the court. Your Honours, my name is Cook, initial A, and I represent Magistrate Barbara, the respondent in this matter. Your Honours, when Mr Singh attended the Sikh religious festival in possession of his kirpan, he possessed a prohibited weapon and did so at the possible detriment to the wider community. I submit that due to 3 imperative distinctions, that Magistrate Barbara did not misdirect herself as to the law, and thus that Mr Singh's appeal should be dismissed with costs. If it pleases the court, I will now move on to my first submission. Firstly, Section 7 of the Weapons Prohibition Act states that any person without being in the possession of a permit is not allowed to use or possess a prohibited weapon. It is irrefutable that the kirpan is a weapon as it contains a blade edge, and even if the court disagreed that it had a sharp blade edge, it contains a considerable point that can be used to injure or maim other people. Further, according to the practices of Guru Gobind Singh, the kirpan cannot be simply of a symbolic size and must be able to significantly harm or maim another person in the role of self-defense. In continuation, I submit that the consideration of whether or not the kirpan is a weapon, the court should apply the purpose of the kirpan, and that it is historically used for self-defense and thus is a prohibited weapon. My learned friend suggested that the court should apply the intent of the kirpan when considering if the kirpan is a dangerous weapon or a knife. However, the intent of the kirpan is historically and religiously to cause harm to another person under the guise of self-defense. And thus, the intent of the kirpan is to injure, and that is why it is carried by Sikhs, because it is a symbolic weapon that is able to injure other people.
As I understand it, there's something in the facts that says the purpose of carrying the kirpan is to do right and do good and to protect the weak, so that it's a symbol rather than something you're ever expected to use as a blade. And if that is the case, that raises the question of whether it's a prohibited weapon within the meaning of the prohibited weapon, the Weapons Prohibition Act. So
yes, Your Honour. In the original facts, it does state that the kirpan is used to defend the suppressed ones or the needy. However, this therefore states that the kirpan must be able to therefore defend someone else, and thus, in defence of someone else, be able to harm another person. And in further research of Sikhism and the Sikh religion, this is confirmed to be upheld by the original articles by Guru Gobind Singh in 1699. May I proceed, Your Honour?
but we now live in an Australia that has different communities. One of those communities, a distinguished community, are the Sikhs. And the Sikhs have these 5 requirements, and the Act is an act of an Australian Parliament, and one would expect, have to be interpreted in a way that would not cut across the multicultural nature of our country, and it would be unthinkable that in a Sikh community meeting there would not be a lot of people. Indeed, if it's a religious meeting, all of them, one would expect, would have a kirpan if they were male.
I agree, Your Honour, that religious freedom is important and the expression of religious freedom. However, I submit that proportion should be considered in the matter of law. The purpose of the kirpan is as a knife and a weapon, and therefore it is very different to, say, a Catholic who holds a rosary in order to pray. And so therefore I submit that freedom of expression is important. However, public safety, as my senior counsel outlined, is primary and should be primary in our society. Otherwise, Your Honours, I submit that a dangerous precedent may be set in which religion may be upheld, and as one of Your Honours stated earlier, perhaps another religion might suggest that dangerous weapons can be also included in their religious doctrine. So therefore, it is important to
I'm glad you mentioned the rosary, because at least it's conceivable that a set of rosary beads could be used to throttle a person and to extinguish all life from the person by such a misuse of rosary beads. So does that make carrying of rosary beads a prohibited weapon?
Your Honour, I would therefore apply the example of a metal ruler. A metal ruler, much like rosary beads, it's metal, it is heavy, it has a sharp edge, it could be used to harm. However, its purpose is for the measurement of perhaps a test paper, and therefore its purpose is innocent in nature. However, the kirpan's purpose is to defend an innocent person, and thus it has to be able to maim another person. So therefore, there is a distinct difference between rosary beads, which are intended to be held for prayer and quite innocent activities, and the kirpan, which is intended to be held simply not of a symbolic size, but to defend and harm another individual.
So your argument is that whatever is the cultural nature of our society, knives are dangerous. Experience teaches that people who have knives may not want to or expect to, or even for most of the time intend to use them, but in a predicament they will sometimes draw out a knife and cause terrible harm to another person and complicate and ruin their own lives. And therefore that our society has set its face against the carrying of knives.
Yes, Your Honour. I agree with the appellant that Mr. Singh is of benevolent character. However, as Your Honour just stated, it is clear that though he perhaps has a benevolent personality, in times of great distress or great detriment to himself or other people, that Mr. Singh may indeed pull out a knife and thus, pull out the kirpan, and thus it is therefore considerable that though his intent may be of expressing his religious freedom, the very act of carrying a knife cannot be upheld just for the purpose of religious freedoms, as ordinary people may then assume that they too can also carry knives in the purpose of defence or the purpose
but as Justice Lander pointed out earlier, and another of the requirements of the Sikhs is that they wear a turban. And if we, as a society, start interfering with the rights to wear a turban and carry the ceremonial knife and so on, we're diminishing our own society to some extent by doing that. Now, is your submission, well, you can try as hard as you like to give a very narrow interpretation to this criminal statute, but you can't get around the fact that it is new legislation, it is specifically targeted at knife carrying. It does have a let-out where the police commissioner gives a permit, but there is no evidence in this case that the permit was given, and therefore, if Mr. Singh wanted to carry his kirpan to a religious ceremony, he should have applied to the police commissioner to get a permit, and not having done so, he is caught by the general prohibition on the carrying of a knife, which the kirpan is.
Yes, Your Honour, that is my submission. May I continue on the issue of the
Have I
permit?
just put your case very clearly and effectively? Is that the way you would put your case? Do you embrace the way in which I expressed the case for the respondent?
Yes, Your Honour, you've put it very clearly. However, if I may continue, I believe that I have some extra points to contribute.
I spent a little time asking my question. We'll give you a couple of minutes to finish your submission. Is there anything else that you need to say?
Yes, Your Honour. Furthermore, Mr. Singh had no genuine reason to possess the prohibited weapon, as there are no considerations under the Weapons Prohibition Act.
He did have a reason to carry it. He's a Sikh. Sikhs carry it. It's important to them. It's part of their identity.
I agree, Your Honour. However, under the Weapons Prohibition Act, there are no exemptions for religious grounds, and even if there was an exemption for recreational activity, Mr. Singh would have had to outline these exemptions when he applied for a permit. However, as he did not apply for a permit, the Weapons Prohibition Act therefore is material in Magistrate Barbara's findings that he did not have a permit and he did possess a prohibited weapon.
Yes, I think this has all been said earlier by the presiding judge. Is there anything else that you wish to say?
Yes, Your Honour. Your Honour, I would further make it explicitly clear that the Weapons Prohibition Act is in fact material in this decision, as it allows Your Honours to make a precedent regarding the use of weaponry and weaponry that could be dangerous to a future society. If Your Honours were to agree that the Kirpan was not a knife and that a permit was not required under the Weapons Prohibition Act, this could constitute a dangerous precedent for future when another individual who may have an object does not believe that they too need a permit under the Weapons Prohibition Act, whether they have good intent or they have a benevolent personality or other reasons supplied by the appellant. So therefore, I would state that the Weapons Prohibition Act is in fact material, and if it pleases the court, I will now conclude my submissions.
Yes. Thank you. Is that the limit of your submissions? I think you've run out of time now.
Yes, Your Honour. If it pleases the court, those are my submissions. May I be of any more assistance?
Thank you very much, Ms. Cook.
Thank you.
Do the plaintiffs wish to exercise any right of reply? Is there any right of reply in the rules? I don't think there is a right of reply. So I think what has just been said by Ms. Cook is the conclusion of the oral submissions, and the court will now adjourn in order to consider the disposition of this application and also the determination of the outcome of the competition. Court will adjourn.
Silence or stand and remain standing.
Please be seated. In this matter, the court was constituted as at present by the order of the Chief Justice. And the court has had the assistance of the submissions, both in writing and orally, of the plaintiff, Mr. Singh, and of the defendant. The court has considered those submissions and it expresses its gratitude for the assistance that it has received. There were three issues in the application. The first issue was whether a kirpan, a ceremonial knife carried by Mr. Singh to a public ceremony of the Sikh community, was a knife. The court has considered the argument that the kirpan was not a knife. We've considered that argument against the background of the provisions in legislation which specifically impose limitations upon the carrying of knives in public, because that legislation, in the case of the Summary Offences Act, was dated 1988 and reinforced by the Weapons Prohibition Act of 1998, it must be assumed that Parliament has imposed, for reasons which seem to it to be good, specific and particular restrictions on the carrying of knives in public. There is an exemption possible under the Weapons Prohibition Act of 1998, but only relevantly where a permit is granted by the Police Commissioner. There was no evidence that such a permit was granted in this case. Accordingly, on the first issue, the court is inclined to the view that the weapon that was carried by Mr. Singh was in fact a knife. It might have been a blunt knife or it might have been a sharp knife, but it falls within the definition and purpose of the legislation. But that is not an end of the matter. For the purpose of a prosecution under the Summary Offences Act, it is still necessary to consider the defence which has been advanced, that the knife was in the custody of Mr. Singh in a public place for specified exempted purposes. One such exempted purpose was participation in a lawful recreation, and another was carrying it for genuine religious purposes. The ceremony at which Mr. Singh was carrying the knife was a recreation, and it was a meeting of the Sikh community. This court is of the opinion, contrary to that taken by the magistrate at first instance, that the defence has been made out and that it was being carried as participation in a recreation and for genuine religious purpose. Any one of those purposes would be sufficient to enliven the exemption. Both of them together make it clear that Mr. Singh was exempted. Accordingly, the conviction under the Summary Offences Act entered by the learned magistrate must be set aside, and in place of that conviction there must be substituted an acquittal of Mr. Singh for the offence with which he was charged under the Summary Offences Act. But that is not an end of the matter. Mr. Singh was also charged with an offence against the Weapons Prohibition Act. The Weapons Prohibition Act does not descend into the detail of the Summary Offences Act, but being a later enactment, was inferentially passed by the New South Wales Parliament in order to respond to the problem of the use of knives in public places as weapons that needed prohibition. An exemption could have been obtained, but there is no evidence that it was obtained in this case. The magistrate did not proceed to consider the Weapons Prohibition Act because she had come to the conclusion that a conviction should be entered under the Summary Offences Act. We have set aside that conviction. However, we must therefore consider the Weapons Prohibition Act. When we do so, and where we consider the specific and complete prohibition on the carrying of unauthorised or unauthorised possession of prohibited weapons, it is clear that that provision applies in this case. There is no evidence that a permit was granted and therefore the offence is made out. The court therefore upholds the claim for the imposition of a penalty which was not imposed by the magistrate, and Mr. Singh will be subject to a penalty in respect of the Weapons Prohibition Act, and we stand over to a later date, notice to be given for the determination of the penalty, if any, that should be imposed on him in these circumstances. We think it is appropriate to call to the notice of the Sikh community that the very strict and complete provisions of the Weapons Prohibition Act, so that they may inform those who participate in ceremonial occasions of those strict provisions, and they may consider applying to the Police Commissioner if it is permissible for a general exemption, or if that is not permissible within the language of Section 7 of the Weapons Prohibition Act, prohibition to specified and named persons, exemption for named and specified persons who are carrying weapons which are Kirpans and are not dangerous weapons. And that is a matter that will have to be attended to by those communities. It's therefore necessary now to proceed to the question of the outcome of this mooting competition. We have already expressed thanks to the Council who assisted the Court greatly to come to its conclusion. We were impressed with the submission by Ms. Wynne, leading counsel for the plaintiff. She spoke with poise and she endeavoured to deal with the questions that were presented by the Court. I have to say to the plaintiffs that the Court found it difficult to adjust itself to the way in which the plaintiffs decided to present their arguments. The way in which the initiating proceedings presented those arguments was logical. Was it a knife? Was it reasonable in the circumstances for it to be carried? Did it fall in the prohibition of the Weapons Act? Instead of doing it that way, for some reason that was never made clear to us, the plaintiffs decided to deal with the first question as part of the second and third question. And that made it difficult for Ms. Wynne to respond to the questions which the Court asked concerning whether the Kirpan was a knife. And that was a difficulty which necessarily resulted in consequences in the marking scale. Ms. Thomas spoke very clearly. She has an excellent voice. She spoke loud and clear, and it must always be remembered that judges normally are very ancient people, and therefore, as you get older, you get a little deaf, and it's therefore very good if you can speak up very loudly and clearly from the bar table, because if you're not heard, your client's arguments will not be properly considered or even considered at all. And it's therefore to Ms. Thomas's credit that she spoke with a loud, clear voice. Ms. Tang didn't cut through the three issues in an unusual way. She dealt with them in their order. She also had very considerable poise and clarity in her presentation, and she was an excellent advocate. And Ms. Cook put her submissions extremely clearly, and she responded very clearly to the questions that were asked of her from the bench. She moved with the flow of the argument, and that was beneficial to her, and it was reflected in the marks that she received. With experience, Ms. Cook will become shrewd and wily, and she will respond to indications from the bench that she is out there in front, and like the horse vow and declare in this year's Melbourne Cup, if you're winning, then you don't risk the fact that you might talk your way into problems by pressing on. You merely retreat and retire from the field of battle. But we congratulate all of the speakers. They brought great credit on their schools, but also on themselves. The court therefore announces that the winning team on the occasion was the Pinball Ladies College. The best oralist as advocate on this occasion was Alison Cook of PLC Pinball, and the moot is determined, as I have indicated earlier. The plaintiff succeeds in respect of the prosecution under the Summary Offences Act, but fails in respect of the prosecution under the Weapons Protection Act, and therefore the orders are as I've earlier indicated. I will ask Justice Landerer if he wishes to add anything either in respect of the outcome of the moot or in respect of the assignment of the winning team and winning advocate.
Thank you. Well, at the outset, may I address Ms Cook and tell her you should take no offence. I am certain His Honour did not mean to compare you to a horse.
Only a winning horse.
Having said that, I must also congratulate you all. We were very impressed with the way you spoke, the way you answered questions, especially in view of your relative age and youth. You've all got a great future ahead of you. For poor old Mr Singh, may I suggest that he gets together with his community because they seem to be caught in the law of uncertainty. On the one hand, certainly it was for religious purposes. On the other hand, they just don't get enough protection. They're caught under the other Act, and also they're caught under the general feeling, well, if you allow that to be worn, you will allow a bomb to be worn. You'll be allowed anything to be worn if it's for religious purposes. So I believe Parliament has to be involved in cleaning this up. Anyhow, having said that, we've decided how the case should go, and I wish you all good luck.
And I'll ask Justice Cody to have the last word.
So my comments are directed to each of you and giving you a little bit of feedback about how you performed. I thought, Crystal, you had a really tough job starting the moot. I think it's always the hardest job to be the first person to speak, so I congratulate you for maintaining your composure, and we certainly gave you a bit of a grilling in terms of the questions that you were asked. So I think that you did really well maintaining and not just running out the door, so I think you did a great job there. And I also think it was the way in which your team structured the argument really was difficult for the bench to follow, and so in that way you bore the brunt of trying to come to grips with that as well. Helena, I thought you did a remarkable job explaining the two issues that you were dealing with, making the argument about the two reasonable excuses, and I thought you did a really good job. You were clear and fluent and were very logical in the way that you presented the arguments. Ms Tang, I think you also were very composed. The only constructive feedback I'd give you is that you were asked about how you were going to structure your argument, and so you had already given us the introduction, and then you went back again and did the introduction. You could have just left that to one side at that point. So it's being able to roll with it as it evolves. But I thought you were really clear in the way in which you presented your arguments. And Alison, I thought you did a great job as well, very smooth, very fluent in the way in which you presented your arguments, and had a clear understanding of the various points around the Kirpan and what that actually meant. So I was really impressed as my first experience, so congratulations to all of you for the work that you did.
Winner of the moot, Pinball Ladies College. Winner of the Best Advocate on the day, Alison Cook.
Congratulations to everybody for a great moot. We will start with the teams, and we'll start with the runner-up, the presentations to the runners-up, OLMC. Just to let everyone know, as these ladies already know, every semi-finalist in this competition is offered a conditional offer of enrolment at Western Sydney University, we urge you, and I know I have done this in both semi-finals for both these teams already, to choose us wisely. Choose the law school here. We'd love to see you in 2-3 years' time. I think most of these ladies are in year 10, so they've still got a while to decide, but we'd love to see you here in a couple of years' time. So please think about that. Okay, can we start with Our Lady of Mercy College as runners-up? So we have Anne Wynne.
Good.
Crystal Wynne.
Congratulations, Crystal.
Helena Thomas.
Well done, Helena.
And Veronica Chakti.
Congratulations, Veronica.
And for the team, for the school, we have a certificate of achievement as runners-up for you to present in your foyer, and Justice Kirby's biography, which he has kindly indicated he will sign for the school shortly after proceedings conclude. So would the team captain like to come and collect those, please?
Well done.
We'll move on to the winners, Pinball Ladies College. We'll do the individual medals first. So we'll start with Miss Alison Cook, who also wins the prize for Best Advocate. Congratulations. I'll give those to His Honour to hand to you.
Congratulations, Alison. Turn around.
Alison. Tara Narayan.
Congratulations.
Tiffany Tang.
Congratulations, Tiffany.
And Vivica Tang.
Congratulations. Well done. Good. And that's the one for the school.
And of course we have the prize for the school, who also get to take home the perpetual trophy. So we may need at least two team members for this, I would think.
Thank you. Good. Okay.
Thank you.
That's good.
Thank you.
Okay.
Thank you. Could I have a round of applause for all competitors, please?